Mr. Anderson.
Oh, I thought they were getting Mr. Munoz.
Let me get a hold of somebody over
Okay, I'm sorry, Mr. Anderson. We will
here.
get soon.
Yes, sir. All
The
right, give me a
state's
second.
lawyer is not there yet.
Okay.
Thank you.
Excuse me. They want somebody else, not me, right?
Oh, okay.
They said
Judge and Mr. Munoz is hard of
gentleman
hearing.
over here.
Okay,
Hi, Judge, who do you want me to bring up?
Mr. Munoz.
Okay, got it. Here in front of this camera here. I'll put these on. I'll put these on the table.
I can hear you kind of.
Yeah, I think I have it
No,
as
it
high
won't
as
be
we
good.
go. We can adjust them. Push down on it.
Okay. Don't tell me. Is this
Want me to adjust them for you?
the one? Is this the one we need the interpreter for?
Yeah.
No, Judge.
I can hear you there.
Okay.
Okay. Because we have Ms. Cortez on there as for interpretation.
No, Judge, I'm the court reporter.
I understand English and Spanish.
Oh, okay. All right.
Yes, sir. Yes.
Okay, let's proceed then. We're ready to go with Mr. Armando Munoz.
Yes, sir.
All right. This is cause number 2019 0D05668, State of Texas versus Armando Munoz. That is your true and correct name, sir?
Yes, sir.
And is your date of birth 2/18 of 1954?
Yes, sir.
All right. And do you recognize your attorney there, Ms. Pages?
Yes, sir. I do.
Okay. And Ms. Pages, do you recognize your client, Mr. Munoz?
Yes, Your Honor.
All right. And Ms. Nelson, you're representing the state here today. Would you please state the plea agreement on the record?
Yes, sir. The plea agreement is to the lesser included offense of a Class A DWI second, 2 years straight probation with a $500 fine probated, no community service, DWI repeat offender school, the victim impact panel, urine and breath analysis, curfew, 3 days ACOP, interlock, and all standard terms and conditions of probation. And had the state gone to trial, we would have proven each and every element.
Okay, yeah, before we go into all of that, I'm going to go back then and make sure on this 3 days ACOP. Let's see, Ms. Pages, have you and your client talked about when he would like to do that, when we want to do that?
Well, I'm not sure. I have discussed it with him, Judge, and I did tell him to bring all of his medication with him today, just in case if you wanted him to do that right now. I wasn't sure when you want him to go in.
Oh, yeah, let's talk to him about it.
Okay.
Mr. Munoz,
Yes, sir.
is that your understanding of the plea agreement? It was
Yes,
just
sir. Yes,
that's
sir.
your understanding of the plea agreement, Ms. Pages.
Yes, Your
Yes.
Honor, and also that he be given credit for any costs with jail time credit, any
Okay.
court costs.
All right, very good. Now, Mr. Munoz, as part of this plea agreement, you've been explained that you have to serve 3 days in jail.
Yes, sir.
Now, when do you want to serve those 3 days? Have you thought about it?
Yes, sir.
When,
As soon as possible.
so would you want to do it like starting today?
Yes, sir.
Okay, well, if you wish, then we can do it today. I would have put it off a little bit if you wanted, but if you've already got everything set up and you're ready, then you'll just have to walk over to the jail, I guess, and check yourself in after this is over.
Yes, sir.
All right. Yes.
Judge, I guess he is far from jail. He's at the virtual police center, so the jail is on Overland. So, Mr. Munoz, you will have to go to the jail in downtown and turn yourself in and take your medication with you.
Plus, Judge, they
Yes,
need the
sir.
paperwork.
Oh, that's right. They're going to need the paperwork. I don't know if they'll have it that quickly.
Excuse me, not unless you want me to go ahead and turn myself in tomorrow morning, or you give me a date.
Well, I'm thinking, let's see. Could you turn yourself in like Friday evening, like at 10 o'clock?
Yes, sir. This coming Friday, right?
What?
This coming Friday?
Yes, tomorrow.
Yes, sir, at 10 o'clock at night or morning.
Right, and then, 10 o'clock at night,
Yes, sir.
and then you would serve that night, and then you would serve all day Saturday, and then I can release you. Who's going to come pick you up to bring you home?
My wife,
Okay, what time could she come pick you up on Sunday morning?
anytime I can get out.
Oh, okay. I mean, I don't want her driving like at 3 or 4 in the morning.
No, if she's got to work, if she's got to drive at night, one of my daughters will bring her.
Okay, why don't we have it set up so that I'll release you at 8 o'clock Sunday morning?
Sounds good.
Because that covers 3 days. That as long as you serve any part of any day, that will cover it. Is that okay with the state?
Yes, sir.
All right. No objection to that, Ms. Pages, I assume.
No, Judge, my only concern is that he be allowed to take his medication. He does have a high blood pressure and he takes meds every day. He takes potassium and creon and some vitamins, as well as high blood pressure medication, as well as a stomach medication. So that's his concern, that he's afraid of, that he's not going to be allowed his meds.
Oh, yeah, I think sometimes they're rather strict on what they let you bring in. Let's hold off on that ACOP then. Let me wait and see how they allow you to bring those medications in. I don't know. And we'll come back next week, maybe Ms. Pages on a Tuesday, and have it where your client's available.
Okay.
And so by then we can talk to the jail, because he's got some rather complex medications, and see what we can do. We're gonna have to talk to the jail how that works. I'm not sure.
Okay, right. Judge,
They don't want they generally don't want people bringing stuff in.
right.
When you're only gonna be there a couple of days and it's critical to, your life, staying alive. I mean, some of this stuff is, if you don't take it, it could be really detrimental. I don't know. I'll have to talk to one of I'm going to talk to the lawyer from the jail about that, from the sheriff's department.
Okay, Judge.
Okay, but that is still the plea agreement. Don't worry about, we'll work out this when you do the 3 days a little bit later, okay?
Yes, sir. Yes, sir.
That is still part of the plea agreement. Okay, now, you understand the plea agreement's not absolutely binding upon me, but should I choose not to follow that plea agreement, to be harsher than that, you could withdraw your plea. We would proceed to a trial. But if I follow the plea agreement, it is final. You cannot appeal the case. You cannot withdraw your plea without my consent, and you would begin serving the probation portion immediately. You understand?
Yes, sir.
Now, we have in front of us some documents marked State's Exhibit 1, the guilty plea waiver forms in this case. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you, in fact, sign these documents?
Yes, sir.
Did you read them before you signed them?
Yes, I did.
Did you understand what you were reading and signing?
Yes, sir.
Did your attorney further explain to you the meaning of these documents?
Yes, she explained to me.
Do you have any question about their meaning?
No, sir.
So that there's never any question, let me briefly explain to you what they mean. Primarily 2 things. First, you're coming into court telling me through a judicial confession, yes, Judge, I did commit the lesser included offense, Class A misdemeanor, DWI 2. And secondly, you're telling me that you understand you're giving up some valuable rights today. The most important of those rights, the right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. You fully understand that.
Yes, sir.
Understanding that, how do you plead then to this lesser Class A misdemeanor, DWI 2, guilty or not guilty?
Guilty.
Entering your plea of guilty freely and voluntarily.
Yes, sir.
Did anybody force you, threaten you, coerce you, or in any way make you plead guilty?
No, sir.
Did anybody promise you anything or persuade you in such a manner you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon?
No, sir. Nobody
Now, you understand the potential punishment for this offense, up to 1 year in the county jail, a fine not to exceed $4,000. But instead of putting you in jail, I can place you on probation for any number of years, not to exceed 2. You understand I'll have to sentence you somewhere within those general guidelines.
Yes, sir.
You are a U.S. citizen?
Yes, sir.
And how old are you, sir?
67
And how far did you go in school?
till 10th grade.
And you can certainly read and write the English language.
Yes, sir.
Have you ever been under the care of a psychiatrist or psychologist for mental health or mental illness issues?
No, sir.
Suffered any serious head injuries?
No, sir.
And you're telling me you are mentally competent, you understand everything that's going on here this afternoon?
Yes, sir.
Okay. Then, counsel, you've had time to go over the facts and circumstances of this case, the legal aspects of the case, and had time to evaluate your client's mental status?
Yes, Your Honor.
And based on all that, are you representing to me that you believe he is mentally competent to enter this plea?
That is correct, Your Honor.
All right. Then based on your representations, Ms. Pages, your representations, Mr. Munoz, the court's observations of you in court, both here today and prior occasions, I find that you are competent to enter this plea. State may summarize the evidence.
Your Honor, had the state gone to trial, we would have proven each and every element beyond a reasonable doubt of the lesser included offense of a Class A DWI second.
No objection, Your Honor.
Received. Based on the evidence before the court finds the evidence sufficient to find the defendant guilty because we have gone over in previous pretrials the specific acts involved and the criminal history of the defendant. So I do find him guilty. I'm ready to proceed upon the issue of punishment. Let me see here. All right. Are you still working or are you retired now, Mr. Munoz?
No, I'm on Social Security now. I'm disability. I had a surgery on gastric cancer.
On what?
Gastric cancer. I don't got no stomach.
Oh my. Okay. And
That's how come I'm supposed to be drinking those the high blood pressure and the other medications that I have.
all right. Now you did say you were married, right?
Yes, sir.
And you have some children. I assume they're adult children.
Yes, sir. Yeah, all of them are adults.
You probably even have some grandchildren.
Yeah, I got some grandchildren.
All right. Well, congratulations.
Thank
Now,
you.
great being a grandparent. So I'm concerned about these medications. What kind of medications are they for?
One is a high blood pressure. The other one is a potassium, a creon, vitamin B12, the D13, the D3, iron, and then sometimes how I feel I gotta drink a Imodium.
Okay.
Because once I eat, I gotta run to the bathroom.
The most critical one you have is this the blood pressure medication, right?
Yes, sir.
If you don't take that one, you could have some very serious medical issues.
Yes, sir. Yeah, I take it every day. Make sure I take it every day.
Okay. All right. Let me, I'm going to try to figure that out. Obviously, Ms. Pages, have you already got the names and, I guess, the amounts that he's supposed to, the prescriptions that he's supposed to have?
I have names, Judge. I don't have amounts like milligrams or whatnot, but I can talk to him and obtain that by next week, Judge.
Okay, if you get that information specifically for me,
Okay.
then I'm going to see if what they can do is either the jail will do one of two things. Either they'll make sure they let him bring those into the jail, or we'll make sure that they have those prescriptions exactly as his prescriptions are on hand when he does check himself in. All
Okay.
right? Because I mean, obviously, part of the punishment is this ACOP, but no one wants to endanger his health or safety. All right? Okay. Is there anything else either side would like to add before I pronounce sentence?
No, Your Honor.
No, Your Honor.
Anything additionally you'd like to say, Mr. Munoz?
No, sir.
Okay, well then I will follow the plea agreement, 2 years probation. And given the terms and conditions as we have stated, the probation department officials that are there with you this afternoon will go over carefully those terms with you, and good luck to you, sir.
Thank you, sir. Thank
Thank
you. Have a nice day.
You too.
Thank you, Your Honor.
All right, let's see if we can have Mr. Anderson come on next.
Yes. Just go ahead and have a seat again, and then we'll call you up when we have your paperwork ready.
Oh, they're gonna have
And Mr. Dixon, you were prepared on this one? You were familiar with this case?
Yes, Your Honor. I didn't have it on, it was not put on my calendar. I don't know why not. I'm sorry.
Oh, it's not your fault. We didn't probably realize it either. All right,
Judge, who's next?
let's do Mr. Anderson next.
Mr. Anderson? Okay.
Yes, I forgot, Ms. Cortez, you're actually doing the court reporting, right?
Yes, Judge, I sure am.
Okay, because I'd
Yes.
forgotten that Laura was still out.
Okay, yes, yes. Yes, Judge.
All right. Okay, now we are here.
I guess those would be helpful, huh?
Yes.
Okay, now we are here in cause 2018-0D04800, the state of Texas versus Charles Anderson, present in court along with his attorney, Mr. Lerma, the state's attorney, Mr. Dixon. Your true and correct name is Charles Anderson, correct?
Yes, sir.
And your date of birth is 12/21 of 1972.
Yes, sir.
And you recognize your attorney there, Mr. Lerma.
Yes, sir.
And Mr. Lerma, you recognize your client, Mr. Anderson.
Yes, Your Honor.
Okay. Now, Mr. Dixon, if you would state the plea agreement for the record for me.
Yes, Your Honor. The plea is taking place in cause number 2018-0D04800, and it's going to encompass the other case that he has that was for engaging in organized criminal activity causing an assault causing bodily injury. I don't see that cause number in front of me, unfortunately. But there's another case pending your court, and this will subsume.
Oh, that's
that as well.
2019. Yeah, it's 2019 0D03736.
Okay, yes. So in this case, he will be pleading only guilty to count 1 and with affirmative deadly weapon finding with a hammer, and we will be dismissing the other counts 2 through 5 are aggravated assault with a deadly weapon and injury to elder/disabled with intent to bodily injury, and count 7, which is tampering, fabricating physical evidence with intent to impair. And along with that, Your Honor, the conditions are
Are you also, wait, are you dismissing then the 2019 3736?
Yes, Your Honor.
Okay.
And I see that. So it is, yes, we will dismissing that along with it. And we will also, in exchange for this plea, will be dismissing Jennifer Anderson's case in cause number 2018-0D04803.
That I believe is his wife.
Yes, Your Honor.
Okay, let me write that also. Dismissing co-defendant Jennifer Anderson. And what was that cause number again?
It's 2018 and then ends with 04803.
.4803. Okay.
Yes, Your Honor.
All right.
And the plea recommendation is community supervision under the deferred adjudication provisions with no early termination for a term of 18 months.
Excuse me, I missed, there was some kind of static went across there. What was the amount of years of probation?
2 years of deferred adjudication community supervision and no early termination for 18 months, Your Honor. And as conditions of his community supervision, he performed 50 hours of community service, that he stay away from the victims listed in the indictment, Armando Padilla, Fernando, and I don't know how you say it, Avetia, that's Aveytia, and Adrian Vela, Liliana Rosales, Axel Vela, and David Griego, take an anger management class, and all other standard conditions of community supervision.
All right. And is that your understanding of the plea agreement, Mr. Laramore?
It is, Your Honor.
Is it also your understanding of the plea agreement, Mr. Anderson?
Yes, Your Honor.
Okay. And now I think you've probably gone over the resolution of this case with the complainants in the case, Mr. Dixon?
Yes,
And they are aware of what's happening.
yes, Your Honor.
Are they in agreement with this resolution, or?
We are working with Armando Padilla to get the cost of his glasses that were damaged through the victim impact fund, or I don't know exactly the formal name of it. I'm sorry off the top of my head. He is not pleased, but he is not
Opposed?
he's not necessarily opposed to it either. He was
Okay.
looking for more time.
All right, but at least they know and they've been informed of what's going on.
Correct, Your Honor.
All right. And then, so now you understand, Mr. Anderson, the plea agreement is not absolutely binding upon me, but should I choose not to follow it, should I choose to be harsher than that, you could withdraw your plea, we could proceed to a trial on this matter. But if I follow the plea agreement, it is final. You cannot withdraw this plea. You cannot appeal this case without my consent. You would begin serving that probation immediately. You understand that?
Yes, Your Honor.
Okay, we have in front of us some documents marked State's Exhibit 1, the guilty plea and waiver forms in this case. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, Your Honor.
Did you read them before you signed them?
Yes, Your Honor.
Did you understand what you were reading and signing?
Yes, Your Honor.
Did your attorney further explain to you the meaning of these documents?
Yes, Your Honor.
Do you have any question about their meaning?
No, Your Honor.
So if there's never any question, let me briefly explain to you what they mean. Primarily two things. First, you're coming into court telling me through a judicial confession, yes, Judge, I wasn't involved in the commission of count number 1 only, either yourself as a party under the laws of parties in the state of Texas. And secondly, you're telling me that you understand you're giving up some valuable rights here today. The most important of those rights is the right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. Do you fully understand that?
Yes, Your Honor.
Understanding that, how do you plead then to count number 1 of the, I guess it's the 4800 case, guilty or not guilty?
Guilty, Your Honor.
Entering your plea of guilty freely and voluntarily?
Yes, sir.
Did anybody force you, threaten you, coerce you, or in any way make you plead guilty?
No, Your Honor.
Did anybody promise you anything or persuade you in such a manner you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon?
No, Your Honor.
Now you understand the potential punishment for this offense is count number 1. Is that going to be a second or a first degree felony?
Second, Your Honor.
Second, I thought so. Okay, so it's the potential punishment for that offense, not less than 2 years nor more than 20 years in prison, a fine not to exceed $10,000. But instead of putting you in prison, I can place you in probation for any number of years, not less than 2 nor more than 10. You understand? I will have to sentence you somewhere within those general guidelines.
Yes, Your Honor.
You are a U.S. citizen.
Yes, Your Honor.
And how old are you now?
I'm 48, Your Honor.
And how far did you go in school?
I went all the way to a technical school with a Harley Davidson school, Your Honor.
All right, so you can certainly read and write the English language.
Yes, Your Honor.
Have you ever been under the care of a psychiatrist or psychologist for mental illness, mental health issues?
No, Your Honor.
Suffered any serious head injuries?
No, Your Honor.
And you're telling me you're mentally competent, you understand everything that's going on here this afternoon?
Yes, Your Honor.
Now, counsel, you've had time to go over the facts and circumstances of these cases, the legal aspects of the cases, and time to evaluate your client's mental status. You have spent a lot of time actually on these cases over the last several years, have you not?
Yes, Your Honor, I have, and Mr. Anderson is competent to proceed, Your Honor.
All right. Then, based on your representations, Mr. Lerma, your representation, Mr. Anderson, the court's observations of you in court, both here today and prior occasions, I find that you're competent to enter this plea. The state may summarize the evidence. So that will be up to you, Mr. Dixon, to give me an additional summary if you on the evidence. Oops, he's frozen. I think maybe he got locked out because he would have responded. He always does. Oh, here he comes. Something happened.
I'm sorry, Your Honor. My computer internet, for some reason, is scawampus.
Well, that happens to us all on occasion, even to the very skilled computer operator, Mr. Lerma. All right. So if you we got to the point where you were going to summarize the evidence for the state.
Your Honor, beyond with a reasonable doubt, the state can prove all the allegations in count one, aggravated assault with a deadly weapon, to wit a hammer.
All right. Any objection to the evidence, Mr. Lerma?
None whatsoever, Your Honor.
All right. Well, the court has gone over the evidence with the attorneys extensively in the past. I am well aware of the facts and circumstances and all criminal history and background of the defendant. I find the evidence is sufficient to find the defendant guilty, but I am not finding you guilty, Mr. Anderson. You understand that because this is a deferred plea. What that means is I will wait until some later date to finally adjudicate or decide this case. That will be based on your conduct. If you do well on probation, of course, there will be no early termination in less than 18 months. But after 18 months, the court could dismiss your probation, or you could serve it all the way out for the full 2 years. And if you complete it successfully, the case against you is dismissed with no finding of guilt. That could hopefully be of some advantage to you in the future, job, things that you're involved in. So that's the good way for it to end. The bad way is if you don't do what you're supposed to do, particularly if you commit other offenses or you abscond and stop reporting, the court could revoke that deferred status, find you guilty, and then sentence you all the way up to 20 years in prison. I wouldn't be limited to just the 2 that you're on probation for. You understand that?
Yes, Your Honor.
Okay, understanding that, you still want me to grant your motion for deferred adjudication?
Yes, Your Honor.
All right. Then I will grant that. We're ready. Like I said, I'm going to follow the recommendation, 2 years deferred. Just a little background. I assume that you're still married.
Yes, sir.
Do you have children?
Yes, Your Honor.
Probably what, adult children or?
I have one minor. Well, she's 17, my daughter.
Okay.
And then I have a 19-year-old also living with me.
Good.
And then my other son's in Arizona right now, working at Arrowhead Harley Davidson, sir.
Are you still working? I think you had a shop or something at one time.
Yes, Your Honor. I'm a business owner and a Busted Knuckle motorcycle garage.
Okay. Very good. Well, I'm going to follow the recommendation, and hopefully everything will go well on the probation, and good luck to you, Mr. Anderson.
Thank you, Your Honor.
Thank you. You could be excused, and the probation department will go over all the terms and conditions with you here in just a moment.
All right. Thank you, Your Honor.
Thank you. Thank you, Mr. Lerma.
Yes, Your Honor. Thank you. My excuse, Your Honor.
You are, and thank you very much, Mr. Dixon.
Yes, thank you, Your Honor. I'm sorry about that.
Not a problem. Okay, let us move on to, I guess, what is the final case of the
Do that one more time.
1 o'clock session, and that is the state of Texas versus Marissa Monsiváis.
Let me bring her up, Your Honor.
All right, thank you.
Stand right here in front of the camera. Make sure you speak loudly. The microphone's on the camera. Okay?
All right. And I think this is going to be Mr. Cox is going to do this one?
Yes, Your Honor.
All right. Yeah, this is one we discussed just a day or two ago, I believe. We had a rather extensive discussion, and so we're ready to resolve this case. This is cause, wait a minute, we got to have the defendant present. Okay. This is cause number, like I said, 2020-0D02271, the state of Texas versus Marissa Monsiváis. Is that your true and correct name, ma'am?
Yes, Your Honor.
All right. And the date of birth, 10/16 of 1992?
Yes,
Is that
sir.
correct?
That's
And
correct.
you recognize your attorney there, Mr. Norris?
Yes, I do.
And Mr. Norris, you recognize your client, Ms. Monsiváis?
Yes, Your Honor.
Okay. And Mr. Cox, you're representing the state, and if you would state the plea agreement on the record?
Your Honor, the plea agreement is that the state will dismiss the intoxication assault charge and reduce the DWI with child passenger to the lesser included offense of DWI Class A with effectively with the BAC above 0.15. It will be a 2-year probation period, $500 fine, ignition interlock, 100 hours of community service, court costs, $60 to Texas Restitution Accounting, UAs, BAs, curfew, DWI, school victims impact panel, and a TAP evaluation.
All right. And is that your understanding of the plea agreement, Mr. Norris?
Yes, Your Honor.
Is it also your understanding of the plea agreement, Ms. Monsiváis?
Yes, Your Honor.
Okay, you understand the plea agreement is not absolutely binding upon me, but should I choose not to follow it, should I choose to be harsher than that, you could withdraw your plea. We could proceed to jury trial on these matters at a later date. But if I follow the plea agreement, it is final. You cannot withdraw your plea. You cannot appeal this case without my consent. You would begin serving that misdemeanor probation immediately. You understand?
Yes, Your Honor.
Now, we have in front of us some documents marked State's Exhibit 1, the guilty plea waiver forms in this case. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, Your Honor.
Did you read them before you signed them?
Yes, Your Honor.
And did you understand what you were reading and signing?
Yes, Your Honor.
Did your attorney further explain to you the meaning of these documents?
Yes, Your Honor.
Do you have any question about their meaning?
No, Your Honor.
So if there's never any question, let me briefly explain to you what they mean. Primarily two things. First, you're coming into court telling me through a judicial confession, yes, Judge, I did commit the lesser offense of DWI Class A with a blood alcohol of over 0.15. And secondly, you're telling me you understand you're giving up some valuable rights here today. The most important of those rights is the right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. You fully understand that.
Yes, Your Honor.
Understanding that, how do you plead then to this Class A misdemeanor lesser included offense, guilty or not guilty?
I plead guilty, Your Honor.
Are you entering your plea of guilty freely and voluntarily?
Yes, Your Honor.
Did anybody force you, threaten you, coerce you, or in any way make you plead guilty?
No, Your Honor.
Did anybody promise you anything or persuade you in such a manner you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon?
No, Your Honor.
Now you understand the potential punishment here is up to 1 year in the county jail, a fine not to exceed $4,000. But instead of putting you in jail, I can place you on probation for any number of years, not to exceed 2. You understand I will sentence you somewhere within those general guidelines.
Yes, Your Honor.
You are a U.S. citizen.
Yes, Your Honor.
How old are you, ma'am?
28 years old, Your Honor.
How far did you go in school?
I have college experience. I have my diploma in medical assisting.
Okay, you can certainly read and write the English language.
Yes, Your Honor.
Have you ever been under the care of a psychiatrist or psychologist for mental health or mental illness issues?
No, Your Honor.
Suffered any serious head injuries?
No, Your Honor.
And are you telling me you are mentally competent? You understand everything that's going on this afternoon?
Yes, Your Honor.
Counsel, you've had time to go over the facts, circumstances of the case, legal aspects of the case, and had time to evaluate your client's mental status?
Yes, Your Honor.
And based on all that, are you also representing to me that you believe she is mentally competent to enter this plea?
I believe she is, Your Honor.
All right. And based on your representations, Mr. Norris, your representations, Ms. Monsiváis, the court's observations of you in court, both here today and prior occasions, I find that you are competent to enter this plea. The state may summarize the evidence.
Your Honor, had this case proceeded to trial, the state would have been prepared to prove beyond reasonable doubt each and every element of the lesser included offense of DWI with a blood alcohol content of above 0.15. And I do want to make clear for the record that this plea agreement was based in significant part upon both a verification that the child involved has apparently suffered no lasting health effects whatsoever, and a complete lack of cooperation on the part of the child and the child's guardian, who happens to be the husband of the defendant. And therefore, what I surmise is that they are in complete accordance with this resolution.
All right. So what we have then is, I think it was informed to me that you verified through medical records that the child is doing well, that really not suffering any ill injuries at all from this incident.
No, none whatsoever, based on the documentation that we had available to us. Effectively, this plea agreement memorializes what we would have been able to prove if this case had gone to trial.
Right. And I think you said that the guardian, which is the father of the child, which is her husband.
Yes, Your Honor.
And, he obviously, does not want anything more severe than this.
That is what I surmise. We made repeated attempts at contact, and were unsuccessful. And I take from that this is what he would like to see occur.
All right. All right. And we have gone over the case, the facts, and the lack of any criminal history in the past on the defendant, I believe. And so we can, I'll go ahead and follow the plea agreement, 2 years straight probation under the terms and conditions that you mentioned. Let's see, ma'am, you're still married?
Yes, Your Honor.
And are you still living together?
Yes, we are.
And your child is doing very well?
Yes, definitely. He had a physical a couple of days ago, and the doctor says he's doing really well.
Now, are you working outside the home presently?
Not at the moment, sir. I'm on maternity leave.
Okay, because I think you've had, was I informed that you had another child or something?
Can you repeat that? I'm sorry, Your Honor.
Okay,
Yes, Judge. She has another.
I believe that I was informed that you've had another child since then?
Yes, correct, Your Honor.
Okay, so you've got now 2 very young children that you're taking care of.
Yes, Your Honor.
Oh. All right. Well, I'm certain that this is the type of experience that would cause someone probably to never drink any alcohol again. I'm pretty sure you've not had a drink since that day, and I could almost be positive that you would never do so again. It's just.
No, Your Honor, that was an experience I would never want to put myself or my children through ever again. And so I'm going to do everything I could never to have to go through this ever again, Your Honor.
Right. And I think on the bond, I don't think there's ever been a positive of a VA on anything, as to my knowledge, correct, Mr. Norris or Mr. Cox?
Yes,
I'm not aware of anything, Your Honor.
yeah, I
And she's
think,
that's been on that a long time too.
yeah, she's been in exact compliance with that, with the monitoring perfectly since she first began.
All right. Well, that'll continue on your probation, but like I said, I almost think from what's happened to you and to your family in this incident, you just probably never going to have anything ever again. I'm sure it's caused a lot of trauma.
Yes, Your Honor, I've always been the type of person to never get myself in trouble. I've always had a clean record since this. I was experiencing a postpartum depression at the time. I didn't know where to seek help, and I relied on the wrong resource. But I definitely have the help now. If I were to ever go through a depression again, I know where to go, and you shouldn't ever have to experience it again. I'm sure of it, Your Honor. I'm
All right.
positive.
Well, good luck to you and your family. And is there anything else, Mr. Norris, Mr. Cox, or Ms. Monsiváis that you would like to say?
And nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
No, Your Honor, thank you.
All right. Well, the probation officers will explain the terms and conditions that you'll be under for the next 2 years, and good luck to you and your family.
I appreciate it. Thank you.
Thank you. All right. You all are excused. I think